held the pen that signed a victim into silence. $47,000. That's what her voice cost that day. The conference room was beige. That's what I remember most clearly. Not even an offensive beige, just neutral, corporate, forgettable. The kind of room where you'd sign a lease or finalize a divorce. She sat across from me, 17 years old, and her hand shook so badly when she reached for the pen that I had to steady the paper for her. 3 pages. Standard non-disclosure agreement. I'd proofread it the night before, made sure every clause was airtight. Confidentiality in perpetuity. Non-disparagement. Liquidated damages of $5 million for breach. Her mother sat beside her, crying quietly, but the girl's face was blank, empty. She signed her name in this cramped, childish handwriting, and I dated it. March 2006. I didn't know I was helping build something that would take 13 years to tear down. My first day at the firm was in October 2003. I was 26, fresh from a second-tier law school, drowning in debt, and desperate to prove I belonged in Manhattan's legal elite. When they told me I'd be working on the Epstein account, I had to Google him. Financier, billionaire, philanthropist, friends with presidents and princes. The name meant nothing to me then. It was just another client. The first meeting wasn't at our offices. Epstein wanted us to come to him. East 71st Street, this massive limestone townhouse between 5th and Madison. I walked in behind 2 senior partners carrying their briefcases like some kind of legal caddy, and I just stopped. The entryway alone was bigger than my apartment. Marble floors, checkered black and white like a chessboard. But that's not what made me stop. The library, floor to ceiling, 3 walls of legal texts, not decorative leather-bound classics, actual case law, reporters on prosecutorial discretion, treatises on civil liability shields, entire sections on settlement agreements and confidentiality law. I'm standing there, staring, and Epstein walks in, smaller than I expected. Quiet voice. He's wearing a navy suit that probably cost more than my car, and he sees me looking at the books. The law isn't a wall you break through, he said. It's a language, and I speak it fluently. At the time, I thought it was brilliant. The team was already assembled by then. This is 2003, remember? Before any charges, before any investigation that I knew about. But Epstein was building his defense like other people build investment portfolios, diversified, strategic. Alan Dershowitz for constitutional law and media strategy, Roy Black for criminal defense, Gerald Lefcourt for federal exposure, Kenneth Starr, yes, that Kenneth Starr for appellate, options. It was like watching a heist crew assemble, except we were the ones planning to rob justice. My role was small at first. Document review, legal research. I'd spend 12-hour days in databases, pulling cases about witness credibility and prosecutorial misconduct. I drafted memos on every Florida judge's sentencing history. I compiled profiles on every detective in the Palm Beach Police Department, their case clearance rates, their disciplinary records, their political affiliations. This was background work, prep work. For what, I didn't ask, but I noticed things. The staff who brought us coffee during meetings looked really young, maybe 16, maybe younger. They wore these identical white polo shirts and moved around the house silent, eyes down. During one meeting, I watched Epstein place his hand on one girl's lower back as she set down a water glass. Just rested his hand there, casual, like he owned her. She didn't react. That's what disturbed me most. She didn't react because she was used to it. I went back to the office that night and found a template in our case files, Standard Employment NDA, dated 2001. I read it at my desk, alone, after everyone else had gone home. Complete confidentiality regarding household operations, social engagements, travel arrangements, and any observations of personal conduct. Employee acknowledges that breach of this agreement will result in immediate termination and legal action for damages not less than $100,000. $100,000 for a housekeeper. That's when I found the other document, buried in a subfolder marked Contingencies, a draft non-prosecution agreement, blank fields where the charges would go, where the sentencing terms would go, but the structure was all there. Immunity provisions, cooperation clauses, sentencing cap recommendations, the date on the file properties, June 2003. This was 4 months before my first day, 2 years before any criminal investigation would begin. Epstein wasn't reacting to legal threats. He was pre-building immunity architecture. March 2005. That's when everything accelerated. A mother walked into the Palm Beach Police Department with her daughter, 14 years old, said she'd been paid $300 to give Jeffrey Epstein a massage at his house, said inappropriate things had happened, said there were other girls. I found out about it before the story hit any newspaper. Found out because within 48 hours of that report being filed, we had a war room, conference room C, 6th floor, whiteboard covering one entire wall, names, dates, connections, not Epstein's connections, the detective's connections, Chief Michael Ryder's connections. We hired private investigators before the police even finished their first interviews. I watched a senior partner brief a PI team on a Tuesday morning. I want to know where Ryder goes for coffee, who his wife has lunch with, what church he attends, if he's having money problems, if his kids are applying to colleges, if he's got a traffic ticket. I want to know everything. The PI nodded, taking notes. This cost $12,000 a week. Epstein approved it with a phone call that took 30 seconds. By Friday, I was reviewing surveillance logs. Subject, that's how they referred to Chief Ryder, like he was the criminal. Subject met with victim's mother at Publix parking lot. 14 minutes, appeared emotional. There were photos, long lens shots of a detective doing his job, treated like evidence of conspiracy. The strategy wasn't to prove Epstein innocent. The strategy was to make prosecution impossible. Another meeting a few weeks later. I'm taking notes while 3 partners discuss isolation strategy. That's what they called it. How to separate the complainant socially, financially, legally. One partner literally said, if we can't discredit her testimony, we make it irrelevant. No testimony, no case. That's when the payments started. My job changed in 2006. I became a courier, not delivering legal documents, delivering settlement offers. The firm didn't frame it that way, of course. These were civil agreements. Compensation for emotional distress. Completely separate from any criminal investigation. Technically legal if you structured it right, if you were careful with the language. I'll never forget the first one I handled personally. A girl, well, I can't tell you her name. NDA, still binding. But I can tell you I met her at a Denny's off Southern Boulevard. She was 17, came alone, ordered coffee she didn't drink. I had a script, not written down, but memorized. The partners had coached me. This is about compensating you for emotional distress and lost opportunities. This is about giving you closure and the ability to move forward. This is separate from any legal proceedings. You have the right to consult an attorney before signing. The offer was $75,000. She looked at the number and started crying. Not sad crying, this confused, overwhelmed crying. $75,000 was more money than her family had ever seen at once, more than her mother made in 2 years. The NDA was attached. 8 pages. I watched her try to read it, her eyes moving over words like liquidated damages and injunctive relief and binding arbitration. She asked me, "Can I still tell the truth if the police ask me?" I gave her the answer I'd been instructed to give. "You can, but you'd be violating our agreement. You'd have to return the money, and we'd pursue damages for breach of contract." She signed. I processed 16 of these agreements between January and August 2006. The amounts varied. $50,000 for girls who'd only been there once, $200,000 for a girl who could testify about multiple incidents, who had corroborating witnesses, who'd kept evidence. The firm had a formula. They literally had a spreadsheet rating exposure levels. Every single agreement had the same core clause: non-disparagement and non-disclosure regarding any interactions with Jeffrey Epstein or any of his associates, employees, or representatives. This includes, but is not limited to, statements to media, law enforcement beyond compelled testimony, other potential witnesses, or any third party. We were building a wall of silence, brick by brick, and each brick cost between $50,000 and $200,000. By 2007, Palm Beach police had 40 witnesses. 40. They'd executed a search warrant on Epstein's house, found evidence I never saw the details of, but enough that the state attorney wanted to charge him with multiple counts. Then the FBI got involved. Federal prosecutors took over the case. That's when Dershowitz personally flew to Miami. I wasn't in those meetings, I was too junior, but I processed the bills afterward, so I know exactly what happened. Dershowitz met with U.S. Attorney Alexander Acosta 4 times in 3 weeks. The strategy, I learned this later from a paralegal who'd been in the room, was mutually assured destruction. If the case went to trial, Epstein's team would subpoena every piece of prosecutorial communication, every internal memo, every email. They'd depose every FBI agent and prosecutor. They'd turn the trial into an examination of investigative procedures, of prosecutorial discretion, of whether Acosta's office had political motivations. It would take years. It would cost millions in federal resources, and Epstein could afford to litigate forever. Acosta blinked. I saw the draft indictment, 53 pages, multiple counts. The paralegal made copies for the files, and one afternoon when the office was quiet, I read the whole thing. It was devastating, detailed, specific. Names, dates, locations, evidence inventories, witness statements. This was an airtight case. It was never filed. Instead, I was called in at 2 a.m. on a Tuesday in September 2007 to proofread a document, the non-prosecution agreement. I remember sitting in the conference room with coffee that had gone cold, reading through it line by line. Epstein would plead guilty to 2 state charges: solicitation, not trafficking, not anything involving minors explicitly, just solicitation. 18 months in county jail, not federal prison. Work release 6 days a week. And then, on page 4, paragraph 3, this sentence: the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein. I stopped, read it again, highlighted it. walked down the hall to a senior partner's office. He was still there at 2 a.m., tie loosened, looking exhausted. "This clause," I said, "this grants immunity to everyone, right? Not just specific people, any potential co-conspirator." He looked at me for a long moment. "That's correct. Who negotiated that? That's above your pay grade. Just proof it for typos." I went back to my desk, finished the proofread, sent my edits. The agreement was finalized 3 days later. It was kept secret from the victims. That detail, that it violated the Crime Victims' Rights Act to negotiate a plea without informing victims, I didn't learn that until 2018. In 2007, I just knew we'd won. The legal team celebrated. There was champagne in the conference room. Epstein sent a case of expensive wine to the office. My supervisor gave me a bonus, $4,000. I bought my first new car. I felt successful. Epstein's sentence started in July 2008, Palm Beach County Jail. I visited him there once, delivering documents that needed signatures. They gave him a private wing, his own security. Team, hired by him, guarded his cell, not from other inmates, from prison staff, making sure he had privacy. Work release meant he left jail 6 days a week, 12 hours a day, to go to his office. His office was his Palm Beach mansion. I filed the logs later as part of the case close-out documentation. 3,200 hours outside the jail during a 13-month sentence. The deputies logged him leaving at 8 a.m., returning at 10 p.m. every day for a year. One deputy later testified, this was in a 2019 proceeding, that they were told Epstein was above their pay grade and to give him whatever he needed. He served 13 months, got out in July 2009, registered as an offender, lowest level, and that was supposed to be the end of it. But my work continued, my new role, monitoring. We set up Google alerts for every victim's name we knew. We monitored social media. Anytime someone posted something that could be interpreted as referencing Epstein, even obliquely, even without naming him, I flagged it, passed it to the partners. They evaluated whether it constituted a breach. In 2011, one girl, woman, by then she was 24, mentioned in a Facebook post about finally being free of a bad situation years ago, didn't name Epstein, didn't specify what situation, just that one line. We sent her a letter. You are in material breach of the confidentiality agreement dated March 2009. You have 48 hours to remove the social media post and provide written assurance of no further violations, or we will pursue liquidated damages of $5 million. She deleted the post within 6 hours. I tracked it. 6 hours from receiving the letter to complete compliance. That's how effective the threat was. $5 million versus deleting 3 words from Facebook. There was no choice. The legal fees alone were the weapon. Even if Epstein lost, even if a judge ruled against him, these women couldn't afford to fight. Our hourly rate was $500. A single motion to dismiss could cost $50,000 to defend. We had unlimited resources. They had none. Every 3 or 4 years, we'd send out settlement refreshers, new agreements, stricter terms, more money. A woman who'd signed for $50,000 in 2006 would get an offer for $100,000 in 2010 to sign a new, broader NDA. Most signed. Why wouldn't they? The alternative was having no money and still being legally silenced. It was a perfect system, and it worked for a decade. I went numb somewhere around 2012. This was just my job. I was good at it. I made partner track in 2015. I bought an apartment in Brooklyn, started dating someone who thought I did corporate contract work, which technically wasn't a lie. I stopped thinking about the conference room, the shaking hands, the girl at Denny's. It was just paperwork, just legal work. Everyone has a job. Then 2018 happened. Trump nominated Acosta for labor secretary. During confirmation hearings, a reporter asked about the Epstein case. Acosta said something that detonated in my head. He said, "I was told Epstein belonged to intelligence and to leave it alone." Intelligence. I pulled every file I had, every memo, every email, every strategy document from 2007. There was nothing. No mention of intelligence agencies, no CIA, no FBI beyond the criminal investigators, no State Department, nothing. But there was one document, a memo from Dershowitz's office with a single line redacted, marked outside scope. I made a call to an FBI agent I'd worked with on a different case, asked him, off the record, if there was an intelligence angle to Epstein. He was quiet for a long time. Then he said, "There were questions we weren't allowed to ask. That's all I can tell you." Everything I thought I understood shifted. The legal machine I'd helped build wasn't the only protection. It was just the visible layer. There was something beneath it, something I'd never been briefed on, never knew existed. For 10 years, I thought I understood what I was part of. Now I didn't know anything. And if there was intelligence protection, why did it fail in 2019? November 2018, Julie K. Brown's investigation published in the Miami Herald. I got the call at home. "Have you seen the Herald piece?" I read it on my phone. 80 victims identified. Details of the non-prosecution agreement. Violations of the Crime Victims' Rights Act documented. Acosta's role exposed. Each victim had a name, an age, a story. Brown had done what we'd spent years preventing. She'd connected them, made them real, made them impossible to ignore. I felt sick. Emergency meeting at the office the next morning. The strategy was to wait it out. This will blow over. We've weathered media attention before, but this was different. The culture had shifted. Me Too had changed the math. Women were challenging NDAs in court and winning. Harvey Weinstein, Roger Ailes, Bill Cosby, powerful men were actually facing consequences. The machine that had protected them was breaking down, and the Southern District of New York opened their own investigation. Not Florida, New York, no connection to Acosta, no old agreements, no pre-negotiated immunity. January 2019. Victims filed a lawsuit to invalidate the non-prosecution agreement. Judge Kenneth Mara ruled in February that Acosta had violated the Crime Victims' Rights Act, that the agreement was negotiated illegally. The foundation we'd built was illegal, had been illegal from the beginning. July 6th, 2019. Epstein arrested at Teterboro Airport. I was in the office when the news broke. Phones ringing everywhere, attorneys scrambling, emergency meetings, panic, new charges, new crimes. And here's the key. These were new charges for new crimes. The 2008 non-prosecution agreement didn't cover them. All that work, all that legal architecture, and there was a gap, a hole we hadn't sealed. Bail hearing. I watched it live on my computer. The prosecutor read from a victim impact statement. He told me powerful people would make sure nothing happened to him. He was right for 13 years. The camera showed Epstein in an orange jumpsuit. Not a $1,000 suit, orange cotton. Standard issue. Bail denied. The moment they said those words, I felt something break. not relief, not satisfaction, just this overwhelming realization that the machine had limits, that it could be broken. The FBI raided his mansion, found evidence we'd protected for a decade, evidence I'd helped keep hidden. This time we couldn't isolate the victims. 60 of them had retained a single attorney. They were coordinating, supporting each other, speaking publicly. The NDAs were being challenged as unconscionable, as products of illegal conspiracy. Women were forfeiting the settlement money to tell their stories. The wall was crumbling. The system didn't fix itself. It was overwhelmed. There were too many voices, too much public attention, too much momentum. We couldn't send 60 cease and desist letters simultaneously without making headlines. We couldn't sue women who were already in the spotlight. The tools that worked in darkness didn't work in daylight. August 10th, 2019. Epstein died in his cell, officially ruled a suicide. I heard the news and felt, I'm ashamed to admit this, relief. Then immediate disgust at feeling relief. Legal team meeting the next day. No one talked about justice or tragedy. We talked about managing civil liability for the estate. Ghislaine Maxwell was still free, still protected, for now. I left the firm 3 weeks later. I didn't blow a whistle, didn't report anything to authorities. I was worried about attorney-client privilege, about my own liability, about my career, about what I'd be admitting to. I just left, started doing contract work, small stuff, keeping my head down. Maxwell was arrested in 2020, convicted in 2021, but so many others were never charged. The potential co-conspirators, protected by that immunity clause, they're still protected, still free. Epstein's estate set up a compensation fund, $121 million paid to 136 women. But to receive it, they had to give up the right to sue the estate. Many are still bound by NDAs with living co-conspirators, still legally silenced. The legal team? Dershowitz is still practicing, still defending himself against allegations, still on TV. Acosta resigned as labor secretary, took a private sector job. The other attorneys are still working, still representing clients. No disbarments, no sanctions. I'm still licensed to practice law. I still have copies of those old NDAs in a storage unit in Queens. Never reported them, never turned them over. Still bound by confidentiality obligations that survive employment, that survive the client's death. People ask me how it happened, how he got away with it for so long. They want a conspiracy, a smoking gun, a simple answer. But it wasn't magic. It was just money turned into labor, legal labor, hundreds of hours of brilliant minds finding every crack in the system, every loophole, every pressure point. And the system let us. The system enabled us. The system was designed to let us. The Crime Victims' Rights Act is enforced more strictly now, but it's still violated regularly, quietly, in cases that don't make headlines. ND. As in these kinds of cases are restricted in 18 states now. 32 states still allow them. Plea deals are still sealed. Wealthy defendants still hire armies of attorneys to engineer immunity. The machine is still running. I helped build it. I profited from it. I stayed silent when I could have spoken. I don't expect forgiveness. I don't think I deserve it. I'm telling you this, telling you the parts I'm legally allowed to tell you, because you need to understand how it works. There's a clause in every NDA we wrote, Section 12, Paragraph 4. It says if this agreement survives in perpetuity, that means forever, even after death, even after conviction. Right now, there are women who legally cannot say his name in connection with what happened to them. The law I helped write is still protecting him.